Good afternoon, everybody. My name is Alexander Rufus Isaacs, and I am the moderator for today's program. Thank you very much for joining us. First of all, a couple of housekeeping announcements. You will receive your NCLE certificate shortly after the program. Your certificate will also be stored at BHBA Plus, our members-only community. And please take a moment to complete the survey that's included with your certificate. We have other great programs coming up soon. On consecutive days between March 25th and April 1st, we have a series entitled Everything You Need to Know About NFTs and the Law. On April 22nd, we have the next program in the War Stories series featuring Yaqub Hazard. And more details of all of our programs can be found on the gleaming new version of the BHBA website at bhba.org. If you enjoy this program and would like to help us put on programs in the future, please consider joining the BHBA litigation section's executive committee. There are only 6 of us. We put on a lot of programs, and frankly, we could really use some help. I will put my email up in the chat room in a minute. So if you're interested, please email me, and I will pass your details on to the committee chair, Rudy Lara. Lastly, the BHBA has over 600 members who are either still in law school or are in their first 3 years of practice. It's a very unsettling time to be entering the profession, and many of them are looking for mentors. So if you are a BHBA member and you would like to be a mentor, please do volunteer. It isn't time consuming and it's very rewarding. I'm going to put up a link in a minute in the Q&A to an intake form for mentors and mentees in a minute. So if you're interested, please enter your details there and we'll take it from there. Now, onto the program. Since California enacted the first anti-SLAPP statute in 1992, many other states have followed suit. The result is an inconsistent patchwork of laws, some broad in scope, some narrow. In 2020, the Uniform Law Commission approved a uniform law entitled the Uniform Public Expression Protection Act, otherwise known as UPEPA. So that's another acronym for you to remember. It has already been adopted in Washington, and Kentucky, Hawaii, Iowa, and Indiana are expected to follow soon. Also in 2020, New York has significantly enlarged its statute. The panel will discuss how the national anti-SLAPP landscape is changing, both at state level, and also will focus on the debates in the federal courts over whether to apply state anti-SLAPP statutes in federal litigation. This is a minimum of 1 hour program. We may go over a little. We will assume some basic knowledge about anti-SLAPP. If you have questions, please do enter them in the chat function, or no, actually in the Q&A function. And if we have time, I will put them to the panel. Given the time constraints, I'm only going to introduce our panelists briefly, but their full bios are in your materials. Firstly, Lane P. Shetterly is a partner at Shetterly, Urich, and Azias in Dallas, Oregon, where he litigates a wide range of cases. He's also vice chair of the Oregon Community Foundation, a member of the Uniform Law Commission from Oregon since 2005. And it was Lane who chaired the Uniform Law Commission Committee, which drafted UPEPA. Laura Lee Prather is a partner with Hayes and Boone in their Austin and Houston offices. She is board certified in civil appellate law and represents a broad array of clients at the trial and appellate court in First Amendment, anti-SLAPP, and IP disputes. She participated as the ABA's advisor on Lane's ULC committee, which drafted UPEPA, and she is now working with the ULC Enactment Committee to have the legislation serve as a model for the passage of anti-SLAPP laws in all 50 states. As an established authority on anti-SLAPP issues, Laura has testified before multiple state legislatures on the need for anti-SLAPP laws at the state level, and also before Congress on the need for federal legislation. Last but not least, Tom Burke is a partner with Davis Wright Tremaine in the firm's San Francisco office. He defends speech and contents across all mediums. With over 30 years of trial and appellate experience, Tom's practice covers the full spectrum of content liability issues, including First Amendment and the defense of libel, privacy, and copyright claims. Tom has successfully handled hundreds of anti-SLAPP motions, been involved in dozens of anti-SLAPP appeals, and is the author of the Anti-SLAPP litigation, the Rutter Group series from 2013 to the present. He also co-edits the Anti-SLAPP chapter of the Rutter Group's Civil Procedure Before Trial treatise, and he served as an observer on Lane's committee. Lane will now kick us off with an explanation of what the Uniform Law Commission is, how he ended up heading this committee, and what led to the drafting of UPEPA. Lane, over to you.
Thank you, Alexander. Good afternoon, everybody. I'm really pleased to be with you today. As Alexander said, I'll just set the table here with a little bit of background on the Uniform Law Commission, our drafting process, and how the Uniform Law Commission came to take up the project of drafting an anti-SLAPP statute. The Uniform Law Commission is an organization of the states representing all 50 states, plus Puerto Rico, District of Columbia, and the U.S. Virgin Islands. The work of the commission is to draft laws that address subjects where uniformity among the states is beneficial and achievable. When an act has been approved by the Uniform Law Commission, it goes out to the state legislatures for them to independently adopt and thereby create a system of uniform statutes among the states. In 2017, the commission undertook this drafting process to create the Uniform Public Expression Protection Act, our anti-SLAPP statute. Let me just say that for definitional purposes, and Alexander said, I think we assume that everybody has a basic understanding of what an anti-SLAPP statute is. For the Uniform Law Commission, our definition, our working definition really is that an anti-SLAPP suit is a suit that is brought not to seek real redress or relief for harm or to vindicate one's legal rights, but rather to silence or intimidate citizens by subjecting them to costly and lengthy litigation for the having exercised their constitutionally protected rights. In looking at the landscape in 2017, there were just over 30 states that had some version of an anti-SLAPP statute. As Alexander said in his introduction, even among those 30-some states, there's a substantial lack of uniformity in terms of what the statutes look like. Several of them are very narrow. In Hawaii, basically, it applies only if you are testifying in front of a planning commission, a zoning board. In other states, they may be broader in terms of the specific scope, but still narrow in terms of the universe of claims or venues to which an anti-SLAPP statute might attach. Other states, such as California, have adopted a much broader approach. Texas had a very broad approach, and we looked at that. And of course, then we had the states that don't have an anti-SLAPP statute at all. As a result of that, what we observed is some degree of forum shopping. Given the nature of the internet and social media, it's pretty easy for a plaintiff to pick the venue that they want to sue in if they're going to file a SLAPP suit. And often that venue may be one that has no direct connection with either of the parties. It may have been chosen just because it's a state that doesn't have an anti-SLAPP statute or a very narrow statute. And so we determined that a uniform statute would be appropriate to create a more consistent system of laws and protection across the country and to mitigate that forum shopping that occurs. The drafting committee that I chaired consisted of a number of uniform law commissioners from a number of states. As Alexander mentioned, we had ABA advisors. Laura was one of our ABA advisors. We had observers. Tom was one of our observers. And the way the Uniform Law Commission works is the committee is made up of commissioners, but then we bring in content experts to help with the process. And those observers and those ABA advisors participate fully in the meetings and deliberations with the Uniform Law Commissioners and really give our committee is a rich degree of experience and knowledge about the areas in which we are working. This committee met over a period of a couple of years in a number of cities around the country. It had a first reading of a draft statute in Anchorage at the first annual meeting where the act was taken up, and then it was passed the following year and approved by the Law Commission to go out to the states. As Alexander said, it's been adopted in Washington. It is under consideration in a number of states this year, and there's a growing sense of momentum and interest in the statute. So we expect to see more enactments as we go. I would just say in closing that in the work of the committee, what we did, we looked at the survey of states, the various statutes that were out there. We tried to identify trends, modern trends among the newer statutes. We tried to identify the best public policy and then shape that policy and capture those trends in creating a new statute that we are really quite proud of to take out to the states for adoption, for enactment. So with that, Alexander, I think I'll end my initial comments and turn it over to Tom and Laura to begin the more direct walkthrough of the act, and then we'll be happy to answer questions as we go.
Thank you, Lane. Tom, Laura, which one of you would like to kick off?
I just want to say, Alexander calls it UPEPA. I call it UPEPA. So, tomato, tomato. Just want to make that clear.
I think I'm going to take the initial walkthrough of the act. And so as Lane has said, the aim of UPEPA was to address this form of judicial harassment, where people are essentially weaponizing the court system and targeting First Amendment rights, targeting the exercise of people's First Amendment rights. And so what UPEPA does is it provides a substantive protection for those rights, and then a method for the court to evaluate the merits of the case early on with a recoupment of fees if it turns out that the case was meritless to begin with, so that the person who shouldn't have been sued to begin with is made whole. That's the core of what UPEPA does. It does that through, I'd say, 5 different features. The first of which is providing an expedited framework. Have the court evaluate the merits of this case, and whether or not there are any merits, on a fast track basis. It does that through setting up a burden shifting framework, and it is something that in some statutes, UPEPA being one of them, there are specific deadlines that are placed within the statute to ensure that it does get immediate attention from the court. The scope of the statute is absolutely critical, and that's something that the ULC did a really good job of looking at all of the other states' laws, looking at the modern trend in what was being protected, and decided from a policy standpoint that a broad scope was important, that it shouldn't be limited by the type of individual or corporation that was filing the suit or on the receiving end of the suit. It shouldn't be limited by the type of cause of action that was being claimed, because artful pleaders can plead around any cause of action. And so they took a very broad approach, which we'll talk about in a minute. And then they have specific features. Broad anti-SLAPP statutes like UPEPA have features such as a stay of discovery, the right to an immediate interlocutory appeal, and the recoupment of fees. So in going through UPEPA specifically, let's start with the broad applicability. And this was where the ULC committee started. Like Lane said, this was a 2-3 year process. In fact, the very last meeting of our committee was in Chicago as the president was declaring a state of emergency for COVID. And we were wondering, how are we going to get home? Are they going to close down the airspace? But we made it here today to tell the story. So broad applicability was one of the key issues, and the one that we needed to address very early on in the process. And the way that we came down on it, the ULC has UPEPA applying to any cause of action. So again, not a specific laundry list of claims or specific types of claims, but it applies to a cause of action asserted in a civil case based on a person's communication in a legislative, executive, judicial, administrative, or other governmental proceeding or communications on an issue under consideration by any of those, and an exercise of a right to free speech or press, right to assembly or petition, or a right of association guaranteed by either your state or your federal constitution about a matter of public concern. So if you're talking about a matter of public concern, this particular law would apply. Now, California is slightly different. They cover a right of petition or a right of petition or free speech in connection with what they call a public issue. That has been interpreted in the Philmon case to basically include a two-part analysis where you're looking at not only the content, but the context of the speech. In the notes for UPEPA, it refers to a US Supreme Court precedent, Snyder versus Phelps, as really a model to look to as to what constitutes this matter of public concern or this public issue. And what Phelps says is it's speech that deals with matters of political, social, or other concern to the community. It's a subject of legitimate news interest or a subject of general interest and of value that concern the public. In Texas, which is where I live, we codified the Snyder versus Phelps standard in our matter of public concern definition. And we also added on any statement or activity regarding a public official or public figure or other person who has drawn substantial attention due to their official acts, fame, notoriety, or celebrity. So we kind of have Snyder versus Phelps plus.
Laura,
Yes.
yeah, Laura, on that, I just want to emphasize that, I mean, we had a lot of discussion within the committee about, do you identify specific kinds of things that are clearly in the public interest, or you do the California approach, which is to say, they've at the moment kind of taken the obscenity approach, you know it when you see it, and not defined it specifically. And that's it's a real tension, because on the one hand, if you don't define it, it may not be protected. But if you define it and you give examples of it, if you fall slightly outside of that, you may not have the protection. So I just wanted to highlight that, that's a real tension in states when they're enacting statutes, and it was certainly a tension within our group.
And I guess I'm here to tell the lessons learned approach to this too. Texas passed our anti-SLAPP statute in 2011, and then we had a significant rewrite of the statute in 2019. And we initially took the approach of enumerating the various things that qualified as a matter of public concern, and we based that on Texas case law and on Supreme Court precedent that these various issues about health and safety concerns, issues about goods and services in the marketplace, things along those lines. And we enumerated them. And we also had our coverage being anything that related to that laundry list. And that was proving to be unwieldy. It was proving to be unwieldy for the courts. The combination of the relates to term, which is a very broad term, and the laundry list really was causing a significant outcry. And so that's when we reevaluated and decided to take the more sort of esoteric approach of, this is what Snyder versus Phelps says. You'll be able to figure out when you see it. And we significantly modified our definition to matter of public concern in the Texas statute in 2019.
Could I just interrupt for a minute and say that in your materials, everybody should have a copy of UPEPA, and it is the annotated version. So all of these case sites are in there in case you're interested in looking at them, along with the text of the statute. Sorry to interrupt. I have one question. Is there a public forum requirement? Must the speech in question be made in a public forum?
No, but courts interpret the context, right? Is the speech that you're making actually impacting the public concern that is out there? And so if you're having a private conversation with somebody, is that impacting the public concern, or is it not impacting the public concern? It's sort of the second part of the Philmon test, the context piece of it.
But certainly something like a letter to the editor, comment on the television news would be within the scope of the protected speech.
Yes.
If it's on a matter of public concern.
But the intent is not to include comments made in private conversations or statements.
It depends. Again, it depends. It depends upon the context. Tom, you might want to add in your experience in that regard.
Because
Yeah, I
that
mean,
is
there
a
are-
requirement, is it not, under the California statute, is that you have to show that a statement in question is made in a public forum.
Well, under California law, there's been a California Supreme Court decision that did protect under the anti-SLAPP statute private conversations that related to a matter of public concern. So again, one of the beauties of the anti-SLAPP statute, both UPEPA and California and otherwise, is that it's not cause of action specific, and every case is different. Every case is unique, and it's really up to practitioners to take advantage of their facts to, potentially bring it into the realm of the anti-SLAPP statute, or to fight vigorously that it's actually very private, really doesn't bear on a public issue, and try and keep it out of the anti-SLAPP statute.
And then we looked at, after we had decided on, okay, we're going to have a broad scope. What are we going to exempt? What limited exceptions do we want to have? And that was very much of a public policy argument. So the way that UPEPA came down on it, they have basically 3 exemptions. One is for claims that are asserted against a governmental unit or an employee acting in official capacity. Claims asserted by a governmental unit or an employee acting in an official capacity if you are enforcing a law to protect against imminent threat to public health or safety. And then a commercial speech exemption, with the goal being not trying to tie up all commercial advertising and Lanham Act type cases. So those were the 3 that UPEPA decided there was a significant public policy argument for having them. They did look at other states. California, for instance, has an exemption, again, for enforcement actions. And then they later added an exemption for commercial speech. Texas has the Swiss cheese approach, where we have a laundry list of exemptions. And a lot of that was, again, part of that 2019 kind of pare back. I think that probably the goal to pare back the coverage could have been accomplished just through the previous modification of the definition of matter of public concern and taking out that relates to, but instead, here in Texas, we do a belts and suspenders approach to things. And so we also added exemptions to the end. And some of our exemptions include misappropriation of trade secrets, family law issues in certain contexts, certain employment related issues. Those were all considered by the ULC and basically rejected because many of them, this was going to get solved with the scope aspect, and many of them just smacked of public sort of people who had lobbied on behalf of a certain industry to make sure that those exemptions were in there. And so it really wasn't sound public policy so much. It was more interest group pandering.
Yeah, I would say in the States, as we're looking at introductions, that issue of exemptions is one of the parts of the act that draws the most conversation. And we can accommodate, and we have accommodated a broader list, a longer list of specific exemptions. Often that comes up, and we evaluate them really against the overarching policy of the act. So it is possible to customize this to some extent. The states have a really compelling interest in itemizing a longer list of specific exemptions. We don't recommend it, but we have accommodated it, and we see that.
Yeah, and one thing I would point out is, the approach taken by the Uniform Law Commission here is exactly what Lane pointed out. If you're in a state where it's considering enacting it, but the process of creating the statute, said, all right, well, we have a statute. Do we really even need to consider exemptions? And the experience in California, experience in Texas was that there are certain exemptions that are likely to be issues, and that weighed in on whether or not states would enact them. And so it's interesting, I think, from my perspective, and I think for Laura's as well, what they ended up enacting, because there are, for example, lesser availabilities of the government to rely on the anti-SLAPP statute, which I've tried to assert in California, not successfully. I think after Park versus CSU, there's lot less uses of the SLAPP statute by government actors. It doesn't just apply to all government speech. But one of the things that's fascinating about the ULC approach is that they hear kind of what's happened for the last several decades in other states and try and come at it with a different approach, which takes into consideration and builds on the experience of the other states.
They get the benefit of everybody else's mistakes, which is great. It's valuable information to have. So there's also the expedited framework, right? The expedited framework being you have to file within a certain period of time. The motion has to be heard within a certain period of time. Some states the court has to rule. The UPEPA suggests that the ruling has to be done within 60 days of the hearing. Other states like California don't have a ruling deadline. So, but UPEPA, again, ULC evaluated how other states were doing it, and that's the approach that they decided to take. The burden shifting framework should be very familiar to most California practitioners because it's very similar. It's, the first prong is the movement establishes that statute applies. Second prong is the respondent. Under UPEPA, it is they establish a prima facie case of each essential element of their claim. In California, they establish a probability that they'll prevail on the claim. And then the third step is either establishing that the plaintiff has failed to state a claim upon which relief can be granted, or there's no genuine issue as to any material fact. And we specifically tried to track the language in Federal Rule of Civil Procedure 12 and 56 on that, because we wanted to be able to not conflict with the federal rules. And UPEPA was very conscientious about not wanting to conflict with the federal rules.
Laura,
if I can ask, sorry, Elaine, after you.
No, go ahead, Alexander.
In California, we have a two-prong approach. UPEPA is proposing a three-prong approach. How is it going to be different in practice? Tom's shaking his head.
Yeah, I'll leave that to Tom.
Well, I think in practice, what is prong three basically, would otherwise be prong two. So it's just, I guess the uniform commissioners wanted to have us do the 3-step instead of the 2-step. But it's basically, I'll leave it to Lane. He's responsible for us dancing differently.
No, what I wanted to say was, yeah, and I think functionally, you would find that it works very much the same. What I was going to say, Laura mentioned the way in which the court is called on to look at this. We did adopt basically a summary judgment kind of standard. One of the reasons Washington was, I should say, in step 3, Washington was interested in this because their statute originally called on the court to weigh evidence and make a determination in the context of an anti-SLAPP motion, and that statute was struck down because it was found by the Washington Supreme Court to violate their constitutional right to trial by jury. So we've avoided that in doing much. I think what California does, again, the court looks at the pleadings, makes a judgment based on the pleadings, whether the allegations assert a prima facie case. And then beyond that, any standard is the summary judgment standard and not a weighing of evidence. And so Washington used UPEPA, they were the first state to adopt, to basically rescue, to reinstate their anti-SLAPP statute that had been struck down because of the nature in which the court was called on to review the motion.
And so then I was going to move on to the part of the statute that gives it teeth, right? We talked about applicability, we talked about sort of how it works, but what gives it teeth are...
Before we move on, Laura, before we leave scope completely, there's an interesting reference in the comment at the beginning of UPEPA under short title, where it quotes from a California case called HUP, which says as follows: while SLAPP suits masquerade as ordinary lawsuits. The conceptual features which reveal them as SLAPPs are that they are generally meritless suits brought by large private interests to deter common citizens from exercising their political or legal rights or to punish them for doing so. That seems to me very much along the lines of the famous old case of David versus Goliath, but it would also appear that you haven't really made a distinction, that you're also allowing the SLAPP statute to be used by Goliath against David. Was that something that the committee debated?
I don't think we, go ahead, Laura.
I think we did talk about this at the very beginning, and what we quickly realized is David and Goliath can take all different forms, right? Right now, there are a number of Russian oligarchs that have filed lawsuits against an individual author and her publishing house for a book that she wrote about Putin. Now, one would think the publishing house might be the Goliath, but it's not. It's the oligarchs, right? It's the people who have the most power. It doesn't necessarily mean the corporation has more power than an individual. Look at Lance Armstrong's history in suing everybody who was speaking out about the truth about him. And he was suing them into silence. Who had more power there? Lance Armstrong or the Sunday Times in the UK, right? There's no way to put some sort of a categorical approach to this, because in some settings, Goliath looks a lot different than in other settings.
Alexander, I think, go ahead, Lane.
No, I was going to say, I think we were respectful that Goliath has constitutional rights too. And so we were agnostic, I think, in that respect, in drafting the statute. I think, again, functionally, it's more common that it's a suit brought by Goliath against David, but the statute applies both ways and protects Goliath's rights equally if Goliath ends up as a defendant in a SLAPP suit.
And Alexander, that's been the law in California for decades. California, started out enacting the prototypical David versus Goliath sort of setting, but within a short period of time, and certainly today and for the last several decades, California statute is agnostic in the same way. If it is a lawsuit where there's uniformity, both in the Uniform Act and the California statute, and I think Texas as well, is that if the action arises out of the exercise of protected free speech and petitioning activity, then the SLAPP statute is going to apply. It doesn't matter whose petitioning or free speech activities are in play. The protection is there.
I do understand that, and I recognize that as part of California law. I'm just expressing frustration on behalf of those of us who represent, what I would call ordinary citizens, as referred to in HUP, the people who are impecunious and are largely represented by lawyers on contingency fees and who do not have assets, who are being basically driven over by large media corporations and are then faced with suing those corporations and with the threat of attorney fees hanging over them, which will, completely destroy their lives. Whereas the other way around, large media corporations are able to absorb a couple of $100,000 without too much of a trouble. And it is a major concern. But I do take your point that it is difficult to, devise a test that is going to protect the little guy against the big guy. But it is an iniquity. And one of the reasons why a lot of us are very upset with anti-SLAPP and feel that although there are the Lance Armstrongs of the world, most defamation plaintiffs are not in that league.
Nor can they bike as far.
Okay, I've made my speech. I'm sorry. I don't mean to be too one-sided on this, but somebody has to put the opposite point of view. I interrupted you, Laura. I apologize.
No worries. I was just going to get to the part of UPEPA that really gives it some teeth. And I would say that most of the time, this actually is a law that helps the little guy. I hear what you're saying, Alexander, but the vast majority of the time, this helps the little guy. And it's one of the things that helps the little guy is the stay of discovery, because that essentially stops the bleeding. So there's a stay of discovery once the SLAPP motion has been filed. If you need to get discovery to respond to the SLAPP motion, you can move to the court to get it. and upon a showing of good cause, you can get limited discovery dealing with the SLAPP motion. UPEPA took the approach of having that stay apply not just to discovery, but also to other proceedings. If there were other hearings or motions that were pending, it stayed those. Again, same theory. You shouldn't be bleeding, stop the bleeding until the issue of whether there is any merit gets decided. They also provided for that stay continuing on through an appeal. If there is an appeal, Texas took a similar approach. I think California's, the discovery stay is stayed upon motion, upon the motion being ruled upon. So different states are different ways. Tom, do y'all typically request a stay once you appeal? Is that how it works?
Well, the stay continues on. Basically, if you've appealed, there's going to be a stay of the trial court with respect to the issues that have gone up on appeal. But as a practical matter, that usually stays the entire action when it's up on appeal.
Yeah, we had issues where we had people fighting in the trial court and the appellate court. And so the legislature had to go back in and specifically address that issue. And again, as a result of our experiences and other states' experiences, UPEPA, was able to address that issue on the front end.
But in keeping with trying to maintain a degree of balance here, in fairness, there are exceptions to the stay, opportunities to ask the court for relief from the stay, to hear motions unrelated to the SLAPP motion or other things in the case. So it's not a lock solid stay in the sense that there are exceptions and there are opportunities for relief from that for limited purposes.
Right. The theory is that that a litigant shouldn't be mired in discovery if the lawsuit shouldn't have been brought to begin with. I mean, that's the overarching theory.
But there's also the principle that the plaintiff should not be deprived of the opportunity to take discovery to find out essential elements of their case, such as, for example, actual malice and being able to depose the person. And so, what in practice it means is that, certainly in California, is that it's far easier to get discovery in federal court than it is in state court while there's a SLAPP motion pending.
There's no stay in federal court.
Right, exactly.
No
so that one can continue to take discovery. Your commission seems to have taken the state point of view rather than the federal point of view of imposing that stay. Was there a debate about that?
Oh, there's plenty of debate. Yeah, but you're right. Yeah, we adopted a model more along the lines of the California statute and other more modern state statutes.
And Alexander, actually, we were carrying your water. People like Laura and others, we spoke out about the fact that the California statute and other statutes kind of envision a single plaintiff, single defendant, but you can have situations where an anti-SLAPP motion is brought where there are multiple defendants with completely different interests. And when there's an anti-SLAPP motion that's been brought, ruled on, and then goes up, you have those defendants frustrated. It's like, why is there a stay? Does a stay apply to me? Can't I do discovery relevant to my case? And so, Alexander, we actually thought exactly of you and tried to carve in some things, for an overzealous commission.
And it's also problematic, is it not, when you have multiple causes of action, only some of which are the subject of the SLAPP motion and others that are not. How did UPEPA resolve in those situations where there are, some of the causes of action are subject to a SLAPP and some are not? Is there a stay on all discovery or just to those causes of action as subject to the SLAPP?
So the stay applies to everything unless you go to the court and request relief. But there is an express carve out for motions to sever if you're dealing with, multiple party situations. There's an express carve out if somebody decides to voluntarily dismiss or non-suit the case. Of course, you can go ahead and do that. You're not, hamstrung in that regard. So there are certain carve outs to the stay provision.
Right.
The second of the sort of what gives it teeth provision is the express right to an immediate appeal. And UPEPA just has it in there. Moving party may appeal as a matter of right from an order that is denying in part or in whole an anti-SLAPP motion. And this is significant because studies that have been conducted on defamation cases and interlocutory appeals of defamation cases have shown that there's about a 70% reversal rate on those interlocutory appeals from the denial of a dispositive motion. So when you're looking at this from a judicial economy standpoint, why do we want to clog up the court system with a trial that's going to ultimately get reversed on appeal? SLAPP helps to weed out those meritless cases expeditiously so that they don't clog up the system. And I know there's been, a fair amount of fodder about, oh, but these SLAPP motions are clogging up the appellate courts. And in fact, that's really a misnomer, because again, studies have been done, and California is great because California has actually required folks to notify the Judicial Council when the SLAPP motion has been filed. Those numbers have been reviewed, studied, and it turns out that anti-SLAPP motions constitute only about 0.041% of the total civil filings and only 1.2% of the appellate opinions. And we have similar numbers in Texas as well. So that is why that is very important. And then the last item that I'll talk about is the fees issue. And the fees, the way that UPEPA came at it, and it's similar to California, is that if a moving party prevails on the motion or a responding party prevails on the motion and the court finds that the motion was frivolous or filed solely with intent to delay the proceedings, then they shall award cost, fees, and expenses. And so I want to be clear here, it's not a straight loser pay statute. It is a statute where if you prevail on the motion, you get your fees. And if your motion was filed similar to the fact that the lawsuit was filed solely for the purpose to harass and drag somebody through the court system, if your motion was filed the same way, in which it was only filed with the intent to delay and it was frivolous to begin with, the courts can award the fees the other way. So that is hugely important. It is significant for three different reasons. One, this is an access to justice issue. People need to be able to get lawyers. This is a way for people to be able to get a lawyer to represent them. And I mean, there are so many horror stories where people have had to, cash in their 401ks, get a second mortgage, et cetera, just to get, a lawyer to represent them when they have been sued into silence for a Facebook post or for reporting on bad actors who have not done what they were supposed to do in the regulatory world. I mean, I can go through a bazillion examples, but this is a significant access to justice issue. It's also simply making the person whole. They should have never been brought into the court system to begin with. It's making them whole. And then the third and probably most important part of it when it comes to the global outlook on this is it is a deterrent. It's a deterrent against repeat offenders, and it is a deterrent against future bad actors. And those were all things that resonated with the committee, and that's why they included the fee provision that they included. I'm done.
Well, again, I think I want to emphasize the balance that the committee was after in this section. Laura is exactly right. As a matter of policy, the purpose of an anti-SLAPP statute is, among other things, to deter people from filing meritless claims. And so attorney fees are awarded if a motion is granted and the court finds that the case was meritless. By the same token, we don't want to encourage meritless anti-SLAPP motions. And so that is why if the court finds that the anti-SLAPP motion was without merit, was filed just for delay, then in that case, the party against whom that motion was filed is also entitled to attorney fees if they prevail in that showing. So we really do see this as a very well-balanced section of the act that protects interest on both sides.
And I have to ask you, though, is it is such a high bar to be able to establish that somebody has an appeal, that a motion was filed frivolously or solely for the purposes of delay. Might I ask, Tom, Laura, who practice in this area, how often do you see a party being able to satisfy that burden? Ever?
Seen it.
I've seen it, and I've urged in my book for judges to more regularly sanction lawyers that are clearly it's one thing to have frivolous language, but you need examples of it. And I think increasingly judges are calling that out, and that's what you need.
The unfettered, right to appeal is, encourages, it basically means that, if you lose a SLAPP motion, if you bring a SLAPP motion and then you lose, in almost all circumstances, unless you file an appeal, it's almost malpractice, is it not? I mean, that's a little,
No, I think it's right.
controversial perhaps, but yet it gives such an advantage to the defense in this situation where they can just slow down the whole process, and it frustrates the plaintiff so much that, there is so we say a borderline frivolous motion filed, which is dismissed by the court, and then the appeal is filed, and, you spend a year and a half or 2 years, bouncing around the appellate system. And, it's a major disincentive for people to, bring cases asserting their rights to in this area.
Alexander, one of the litmus tests that a now retired appellate court justice told me about, which was I'd never heard of it before. He told me, Tom, I see all these frivolous anti-SLAPP appeals all the time. And I said, well, how do you know? And he said, well, because they appeal, but they never argued that they should prevail on prong 2. And I told him, I said, well, I don't think my law firm has ever brought an appeal where they didn't try and argue and encourage the appellate court to rule in their favor on prong 2. And I think that's really kind of a difference. You can kind of, if you've just filed an appeal to get the, the delay that invariably comes, and you're not arguing prong 2, you might call somebody out on that. But I think there's far more uses of the SLAPP statute where defendants who maybe have lost in the trial court and file an appeal, they want the Court of Appeal to decide it as a matter of law on prong 2.
I would like to, if I may, put up on the share screen an interesting statement by a California Court of Appeal. It's a case called Hewlett-Packard versus Oracle. It's a 2015 case from the 6th District. And you can see it's a server manufacturer brings action against software developer for breach of contract. So certainly not a classic invasion of First Amendment rights. Here's what the justice says. The case thus provides yet another illustration of the many ways in which the current anti-SLAPP statute produces unintended and even perverse results. It can be argued that the overbreadth of the statute has made the cure worse than the disease. To be sure, the statute achieves its intended purpose in true SLAPP cases, i.e. patently meritless cases brought to punish and harass adversaries in the public arena. But if it makes short work of suits like this, it makes much longer and more expensive work of such suits bearing no resemblance to the targeted paradigm. It's as if a city had decided to cure an illness, afflicting a few of its residents by lacing the water supply with a chemical that would indeed cure those sufferers, but would sicken a larger number of previously healthy citizens. And it goes on to suggest here that perhaps the right of appeal there should be some limitations. For example, that it should not be available if the SLAPP motion is filed more than 60 days out. And also it should not be allowed if it wouldn't dispose of the entire action. Do you think that any restrictions on the right of appeal are justified, or do you think they are unacceptable?
I guess my feeling is that, as to the second condition, especially after in California, Burrell versus Schnitt, you can use an anti-SLAPP motion to target particular claims or portions of causes of action. So no, I would not eliminate the right of appeal if it didn't get rid of the entire lawsuit. That's not, that doesn't make any sense. As to the first point, I'm fine with that. And actually the facts, I would be fine with that if the legislature chose to do that. But, we all know it from law school that bad facts make bad law. And I think the case that commentary arises from, I mean, my family calls me dramatic at times. I mean, that language is a little over the top, I think everybody can admit. But it's an instance where it was a very, very late filed anti-SLAPP motion. And, if the court's really bothered by it, find it frivolous and sanction counsel. That's going to go a lot longer than than writing opinions that people read and say, yeah, but when's somebody going to do something about it? If the legislature is really concerned, they will. I don't think that case merits change by the legislature. I think there are plenty of examples, and they are before the appellate courts who write and complain about them, and they need to, issue sanctions.
Thank you. Should we move on? I think, Laura, do we have anything else to cover on are we going to now perhaps turn over to the next phase of the thing, which is Lane is going to explain to us how the landscape is changing and how UPEPA, right, is being adopted. There you go. I'm coming over to your side, Tom.
Yeah. Very briefly, because I want to give Tom, I think, Tom, you're going to talk about federal court. I did mention that Washington was the first state to adopt the act last year. That was the first legislative session for the act. We have had hearings in a number of states now. I think we're probably active in about 6 states. We had a hearing just a couple of weeks ago in Hawaii. It moved out of the Senate Judiciary Committee unanimously. It's passed the House floor in Kentucky unanimously. Being looked at in Iowa, Indiana, a number of other states, and we're already getting preliminary interest for next year. In many states, this even numbered year is a truncated legislative session, so often has shorter agendas, shorter time limits, and less activity. So even to see the level of interest that we're seeing this year is encouraging. But again, interest from a number of other states looking forward to next year. I think we'll start to see some broader enactment. So at this point, we're considering the early interest to be very encouraging for a fairly broad adoption. And the states that have anti-SLAPP statutes already on the books, we created UPEPA for 2 purposes. One, it could be adopted in whole by a state that just did not have an anti-SLAPP statute. It can also be used by states that have an anti-SLAPP statute as a model to amend their statute to bring it more in conformity with the modern trends and more in uniformity with other states that are adopting UPEPA. That's Hawaii, for instance. Hawaii has an anti-SLAPP statute, but I mentioned it's very narrow. I think it just applies to someone who testifies in a planning commission kind of hearing. They're looking at it to not, of course, create a new statute, but a first instance anti-SLAPP statute, but to broaden theirs to make it more uniform with the approach that UPEPA is taking. So we're seeing states that have statutes look at it. We're seeing states that don't have it look at it. And I do expect that by next year, we should have some pretty vigorous activity in the states adopting.
I'm going to put up on the screen briefly a map of how SLAPP statutes are being adopted nationwide. You don't have to remember all of these. This map is in your materials, but it gives a very useful overview. And thank you. I think it was Tom or Laura who provided this. It's very helpful. There's also an analysis by an organization whose name escapes me for the time being, that's also in your materials. That is
Institute for Free Speech.
Yeah,
that's the one. Yep. That they explain what is happening on a state-by-state basis, which is very helpful. Okay, how are the federal courts reacting to all these state laws? Anybody want to tackle that?
I'll take that, Alexander. And I know we have only a few minutes to fit within the hour. And if we go over, you tell me if I should not go further. But
no, you keep going.
Yeah, the big picture for people to understand is that the hot topic, I think, for anti-SLAPP in federal court is whether or not ultimately the U.S. Supreme Court is going to swoop in and say anti-SLAPP statutes should not be available in federal court, which would be, in my view and others, a real bad thing. And so I wanted to give you a bit of an overview of what's going on in that area. And I wanted to start out kind of where we started this program, and that is to give you kind of an overview very briefly of what statutes are available and the broad variety of them. And I put into the chat the group's report card that Alexander just mentioned. It's something, it's the second year that they've done it, but it's a group called the Institute for Free Speech, and they basically grade the qualities and the effectiveness of anti-SLAPP statutes state by state. It's very clever. You can check on a state and they'll give you a grade. Arizona, for example, if there's anybody in the audience, you know, you are practicing in a D- state. And so
they have a bill pending right now.
They do. And let's hope that they can improve their grade. The reason I'm mentioning this is that, you know, although there's 31 different states with SLAPP statutes, your mileage varies. Some are very strong, like California's, Texas's, and of course, the Uniform Law Commission's model statute is hopefully going to be viewed as a very strong contender. You know, there are other states that have basically had to reenact statutes. There was a mention of the Washington State statute. My DWT partner, Bruce Johnson, was involved in enacting that statute, UPEPA, basically in Washington State at the end of last year. And the reason for that is significant when it comes to the issue of how SLAPP is used in federal court. In Washington State, the state Supreme Court basically shut down the previous statute because it had some overly, you know, what essentially the court found were unconstitutional provisions. It made it too difficult for clients, you know, like Alexander typically represents, to, you know, be able to get to court. And as a consequence, they struck it down. They didn't try and harmonize anything. They just said, start all over. And same thing happened a few years later in Minnesota. Exactly the same thing. And so I'm mentioning this background because when you start to hear discussions about whether or not the federal courts should allow an anti-SLAPP statute, please, and I would encourage you, you know, when those decisions come down, remember that they're not speaking generally. They can't be speaking generally because statutes vary. There are different provisions in various statutes. And so when you read a provision that says, okay, well, you know, this court has struck down the availability of this statute, you have to ask whether or not that same provision, which has been struck down, exists in another state's statute. They're not all the same. Increasingly, they may move towards that, but that's really a critical difference because courts analyzing them will need to keep that in mind. An example is the Ninth Circuit. For the majority of those in this audience, the Ninth Circuit provides strong anti-SLAPP statutes in California, Nevada, Washington State, and Oregon. Arizona statute, as I mentioned, is a D-. Other statutes are very narrow. But with all those protections, even in the Ninth Circuit, there's only a few provisions that have ever been available in the last several decades. One is the ability to recover attorney's fees, and the other is the right of interlocutory appeal. For example, the automatic stay of discovery, the timing issues of when an anti-SLAPP motion will be heard, the ability to prevent amendments to a complaint, none of those provisions are available that are available in state court under, say, the California statute and the Oregon statute and the Nevada statute. None of those are available in federal litigation. They haven't been. And the reason for that is because they conflict with the federal rules of procedure. Again, that's not news. That's been the rule for decades. So what's happening then with that background with the federal courts? There is a trend, no doubt, a trend of federal courts rejecting certain aspects of anti-SLAPP statutes from being available in federal court. The Fifth Circuit rejected Texas's statute. The 11th Circuit rejected Georgia's statute. The DC Circuit rejected the DC statute, and it's likely to succeed on the merits standard for dismissal. The Second Circuit has ruled that California's statute did not apply in federal court, although that's not the law in the Ninth Circuit. These courts have generally reasoned that the dismissal procedures set out in anti-SLAPP questions in question, the specific statutes that are being looked at in those cases, conflict with the procedures under Rule 12 and Rule 56 of the Federal Rules of Procedure. But the Ninth Circuit really stands in contrast, and at this point is now in the minority of federal circuits. The Ninth Circuit's approach tries to harmonize the potential conflicts between anti-SLAPP statutes, again, speaking generally, in all of their variety, and the federal rules by doing the following. And if you don't know this case, it's in the materials. It's Planned Parenthood Federation of America versus the Center for Medical Progress. The site is 890, Fed 3rd, 828. The jump site is 833 to 834. It's a 2018 decision from the Ninth Circuit. And what it does is it basically says, when it comes to deciding whether or not the motion should be granted, they follow a Rule 12 standard or a Rule 56 motion standard, depending on whether or not they're looking at evidence, which is Rule 56, or if it's just a legal question, it's Rule 12. And so those challenging the availability of the anti-SLAPP statute within federal courts and the Ninth Circuit generally are now arguing that other circuit courts got it right. But in my view, and I think in others, those courts have not looked at how the Ninth Circuit sidesteps the conflicts by applying the federal rules 12 and 56 motions when they analyze those. So, you may hear a lot of chatter, and there is a lot of chatter about other states striking them down, but they haven't analyzed in those cases the Rule 12 and Rule 56 sorts of standard. There's a few cases to watch, and then I'll wrap up. In the Second Circuit, there's a case called Coleman versus Grand. And in that case, the Eastern District of New York applied New York's anti-SLAPP statute's actual malice standard and dismissed the plaintiff's libel claim under Rule 56. I know that there was an adjournment requested, but otherwise, oral argument in that case is scheduled for next week, April 13th. So definitely one to watch, Coleman versus Grand. In the Ninth Circuit, there are a pair of cases that libel plaintiffs have joined forces to challenge two libel cases that were decided for the defendants. One is Planet Aid versus the Center for Investigative Reporting. It's a libel action brought by a nonprofit that involved about 80 statements and 20 publications arising from the defendants' 18-month investigation into the alleged misuse of British and federal aid to farmers in Malawi, Africa. After 2 years of discovery, including the depositions of the writers and the editors at the Center for Investigative Reporting, over a dozen discovery disputes, the trial court dismissed plaintiff's lawsuit on the grounds that plaintiffs could not demonstrate that CIR published the challenge statements with actual malice, relying on the standards of Rule 56. The court considered 35 declarations and evidence submitted by the parties. Case was dismissed, and this is a correct figure. The defendants moved to recover some $4.5 million in attorney's fees, which is about 8 times higher than any other attorney's fees award in a SLAPP case. I think the highest at the moment is a case called Resolute versus Greenpeace, some $800,000 in attorney's fees. The second case is CoreCivic versus Candide Group. That's a libel action brought by a private prison group that arose from statements posted to Forbes.com about, among other things, the private prison group's connection to the separation of families at the border. U.S. District Court Judge William Alsup dismissed the lawsuit on the basis of Rule 12b-6 in the context of an anti-SLAPP motion. The defendants also moved for the recovery of their fees, and on appeal, CoreCivic, the plaintiff, argues that the recovery of attorney's fees under California's anti-SLAPP statute is inconsistent with Rule 11 of the Federal Rules of Procedure and violates the U.S. Supreme Court's decisions in Erie versus Tompkins and Shady Grove. In defendants' view, the Ninth Circuit crafted its Planned Parenthood decision intentionally to avoid any conflict with the Federal Rules of Procedure, and that the recovery of attorney's fees after litigation is over is a substantive right to protect petitioning and free speech activities, not a procedural right. The Clare Locke firm, which is familiar to many as a plaintiff's firm, filed an amici brief in the Planet Aid litigation, where the issue of whether or not the anti-SLAPP statute should be available in federal court was not preserved for appeal. But Clairlock also represents the private prison group and Core Civic and the Core Civic appeal, and not surprisingly devoted all but 6 pages of their appellate opening brief to the argument that the anti-SLAPP statute and the recovery of attorney's fees should not be available in the Ninth Circuit. Argument is scheduled in both of those cases. I represent the defendants in both of those cases. The clerk of the Ninth Circuit has told me that they really want to schedule them for the settings that are taking place in San Francisco, and that they want to hear those cases back to back. So it will be Libel Day, most likely in June in the Ninth Circuit this summer. Alexander?
Thank you very much. Does anybody have anything to add to that? Okay, then I think we have gone over our time by 6 minutes. Otherwise, it's been a fascinating and a very interesting panel. The materials should have already gone out by email. If they haven't, they'll go out to everybody who registered shortly after the end of the proceedings, and you'll get your MCLE certificate as well. And with that, it only leaves me to thank very much Lane Shetterly, Laura Lee Prather, and Tom Burke for giving us the benefits of their insights and considerable wisdom on this very controversial subject. Not all of us like it, but we all recognize that it's a fascinating playground. And, you know, particularly the way these 2 cases that Tom is handling come down is going to be very influential. So we look forward to following the progress of UPEPA. And with that, I will call the proceedings to a close and thank everybody for attending. And I'm sorry that we weren't able to get to the questions that people posed.
Thanks very much.
Thank you.
Thanks very much.